Hey everyone, today we're diving into a really important case, Pollo versus Davis. This is a landmark Supreme Court decision that really gets into the nitty-gritty of employee privacy versus an employer's authority. Honestly, what came out of this case might just change the way you look at your work computer forever.
So, let's start with the big question, the one that's at the very heart of this whole thing. Can your boss legally go through the files on your work computer without your okay? Now, for most of us, that's just a hypothetical. But for Pollo, a specialist at the Civil Service Commission, this became his reality. All right, let's get into the facts of the case. It all kicked off on January 3, 2007. At 2:30 in the afternoon, a secret anonymous letter shows up on the desk of the CSC chairperson, Karina David. By that same afternoon, we're talking just hours later, she'd already put together an IT team and sent out a memo ordering a backup of computer files. And by 5:30 p.m., that team was on site, starting the backup. I mean, things moved incredibly fast. So you're probably wondering what on earth was in that letter. Well, it claimed that an employee, the chief of the Public Assistance and Liaison Division, to be exact, was secretly doing lawyering work for people who had pending cases with the CSC. That is a huge allegation of misconduct and a massive conflict of interest. And that letter? It was the spark that lit the whole fire.
Okay, so the IT team gets to the regional office and starts their work. They begin backing up every single file on the computers in Pollo's division. Now, here's a key detail. Pollo wasn't in the office at the time, but he was notified by text message that the search was happening. The whole backup operation was done and dusted by 10 o'clock that night.
So, what did they actually find? Well, on the computer assigned to Mr. Pollo, the team uncovered 42 documents that seemed to back up the claims in the anonymous letter. And these weren't just some random files. They were draft legal documents. We're talking motions, petitions for real active cases that were before the CSC and other courts.
Well, this discovery led to formal charges against Pollo. But he didn't just take it lying down. He fought back, and his entire defense was built on this foundational principle. Article 3, Section 2 of the Constitution. You know, the right against unreasonable searches and seizures. It's the cornerstone of our right to privacy. He argued that the whole computer search was flat out unconstitutional.
Pollo's legal team called the search an illegal fishing expedition because it was done without a warrant. And because of that, he argued that those 42 documents were, in legal terms, the fruit of the poisonous tree. That means any evidence you get from an illegal search can't be used against you. This put a huge question squarely before the Supreme Court. Was the search actually legal?
Now, to figure that out, the court had to make a really important distinction between two kinds of searches. You have your classic criminal search by the police, right? That absolutely needs a warrant from a judge based on probable cause. But then you have a workplace search done by an employer who's just investigating work-related misconduct. That's a whole different ballgame. It's not judged on probable cause, but on a standard of reasonableness.
And after looking at it through that lens of reasonableness, the Supreme Court reached a very clear, very direct conclusion. The search of Pollo's work computer, it was perfectly valid.
Okay, I know what you're thinking. How in the world can a search of someone's files without a warrant be considered valid? That's the core of this whole ruling. And the answer really boils down to two things: a pre-existing policy and a specific legal test the court used.
The first piece of the puzzle, and this was absolutely the game changer, was the CSC's own computer use policy. The language in this thing was crystal clear. It said computers are government property for business use only. And then came the killer lines. Employees have no expectation of privacy and expressly waive any right to privacy. The policy basically told every single employee, we can look.
The court also looked at a U.S. Supreme Court case called O'Connor v. Ortega. Now, why does that matter? Because that case established the idea that when a public employer is investigating work-related misconduct, they don't necessarily need a warrant. The search just has to be reasonable. This U.S. case became the yardstick for the Philippine court's own analysis.
So the court used a two-part test for reasonableness. First, was the search justified from the very beginning? The court said, yes, that anonymous letter was detailed enough to give them reasonable grounds to suspect something was wrong. And second, was the search reasonable in its scope? Again, the court said, yes, they only backed up the computer files, which was directly related to investigating the lawyering allegations. They didn't go overboard.
And all of this brings us to the ratio decidendi, which is just a fancy legal term for the core reason behind the decision.
Basically, because there was a clear office policy stripping away the expectation of privacy, and because the search itself was both justified and reasonable, Pollo's constitutional argument just couldn't hold up.
So with the evidence now officially admissible, the Civil Service Commission found Pollo guilty on a whole host of administrative charges: dishonesty, grave misconduct, conduct prejudicial to the best interest of the service, and even violating the Code of Conduct for public officials.
The disposition, that's the court's final order, was therefore simple and direct. Pollo's petition was denied. His dismissal from government service was affirmed. End of the line.
So the legal doctrine that this case created is now a major precedent. It says that a government employee has no reasonable expectation of privacy on a government-issued computer, especially when there's a policy that says so. And a search without a warrant for employee misconduct is totally valid, as long as it passes that two-part reasonableness test. The ruling in Pollo v. David really did redraw the map for digital privacy in the workplace. And I think the big takeaway for all of us is to take a hard look at our own jobs. You know, think about your company's policies, the computer you use every day. After hearing all this, do you think you have a reasonable expectation of privacy at work? It's definitely something to think about. Thanks for joining me for this explainer.